Good afternoon. How is everyone doing today? Good. Great. Okay. We managing okay? We're almost to the end. So you guys are doing great. All right. So let's start with a couple of administrative things, and let me begin by saying I appreciate you guys being flexible with me today and letting me deliver this class online. So I appreciate that. I've been advised that, in fact, the last week, the dead week rules here are stricter than at prior institutions that I've been at. So at prior institutions, the dead week rules were that no assignments could be due during dead week. Whereas I've been advised that here at UE, the expectation is that no new material will be covered during dead week. So we're going to begin today talking about registration, and then I'm going to upload the video to replace Tuesday's lecture that will finish that. And then next week, we'll just see what's going on with that. But next Thursday, the lecture will definitely be a review session. So bring your questions, et cetera, et cetera. So let's talk about registration. And first of all, let's be clear that there is registration and there is recording, okay? And these are two different ways for the state to maintain a record of the chain of title. And there are places where both are in use in the Caribbean. So there are some places that, at least according to the best information I was able to find, still use a deed recording system. There are places where there's title registration, and there are places where there are both. So most of the cases that deal with registration issues deal with Jamaica. But the statute is a little bit different from place to place. And so it is important to make sure that you know the variations on the statute based on your local law, so wherever you're practicing, and you should be able to explain either why the Jamaica decisions apply or why they don't. Not necessarily in this class, but just in general. So in registration, we talk about absolute title and qualified title. So absolute title and qualified title. Here, I'll put that in the chat for you. So absolute title versus qualified title. And absolute title just means fee simple, okay? If the registrar of title has awarded you absolute title, then you now own fee simple, okay? If you are issued qualified title, then there are other encumbrances or interests that affect your title that are in the registry, okay? So if somebody has registered an easement or they've registered a future interest, or they've registered a mortgage, then those types of things will qualify your title and you take subject to them. Okay? So does this make sense so far? Sure, absolutely. I can repeat it. So absolute title means fee simple absolute. So if you file adequately and the registrar finds no encumbrances in the chain of title, you are issued absolute title, which means you now own fee simple absolute. Okay. With qualified title, what that means is that you seek to have your title registered, and the registrar has found in the chain of title some other encumbrance or interest that affects your title. Okay. And if that happens, you still get title, but you take it subject to these encumbrances and interests that the registrar has found that qualify your title. So does that help? Is that clearer? I think I just repeated myself, so let me know if you need a different explanation. Go ahead, Nakira. Nakira, you came off mute. Did you have something you wanted to say?
I just come in a lecture. I want to know. Never mind.
Okay. Well, let me know if you are able to ask your question, because I want to make sure that we get you squared away. So, so in order to register your title, right, you file the complete set of documents that sort of provide the proof of your interest. Okay, so that may mean that you're filing a deed. It may mean that you're filing a contract. There may be correspondence involved, just whatever has to be filed, you file it in order to prove up your interest. The registrar of titles will then appoint a referee, and I'm unable to tell whether there's a like one referee who sort of does this, or whether this is something that gets distributed throughout the legal community. But the registrar appoints a referee to examine your submission and determine whether the certificate of title should be issued. Okay. If the referee determines that it should be issued, then what happens next is there's a notice of provisional approval. And that notice is intended to make sure that if there's anybody out there who needs to come in and go, hey, wait a minute, I have an interest that should be protected, that they know they need to come and do it. Okay. So when that notice is issued, it is served via publication. It's served via mail on anyone who's known to have an interest in the land. And then there is a waiting period, right? As with any other service issue, we give folks some time to respond. And at the end of that time, in Jamaica, it's 7 weeks. At the end of that time, if no one has come forward and sought to prevent the issuance of the certificate through filing what's called a caveat, then the provisional notice becomes final, the certificate of title is issued. And here endeth the conversation. Because if you hold a registered title, your title is indefeasible. okay? This is the incentive to register in a registration system, is the state says nobody can displace you once you are registered, once you hold a certificate of title, okay? So it doesn't matter if the person who sold you the land didn't actually own it. Doesn't matter if they sell it to two people one day after another. In a title registration system, if the state issues the certificate of title, then we no longer inquire any further. Okay, so do we understand, do we feel comfortable with the indefeasibility of title issue? One yes. Adrian,
Hi, sir. Oh, sorry.
Adrian first, and then Michaela.
Sir, so you're telling me that the state guarantees your title once you've registered it?
Yes, that is exactly what it means. The state actually assumes liability for errors in the chain of title. So if someone has been dispossessed through a mistake in the title registration system, the state is liable, not anyone else.
It's true. Thank you.
Yep. Okay, Michaela, you had a question?
Right. I was just making sure that when you said the caveat, that would be the 8 weeks for Jamaica?
Yeah, that's specific to the Jamaica Act. I'm not going to, I don't have any information about how the process works in other jurisdictions, because the vast majority of the cases deal with Jamaica.
Sir,
yes.
Michaela just said 8 weeks, but I wrote down you said 7 weeks. Which is it, 7 or 8?
It's 7, as I understand it. So.
Okay, all right, thank you.
Okay. So, one second. Okay. There is an exception to the indefeasibility of title. But I should warn you that the cases that are relied on in the books regarding this aren't Caribbean. They're from New Zealand, they're Privy Council cases, so grain of salt. This may not, you should tread with caution in relying on this. And that is that actual notice of fraud may defeat a registered title. Okay, so the cases in question relate to people who forge someone's signature and use that to obtain a certificate of title, and then the courts rule that the certificate of title can be set aside. Okay, but absent that fraud, and it has to be fraud in the procurement of the certificate of title, not fraud in the land transaction or fraud in the representation of sale. Absent that, your title is indefeasible. Okay. And just to, I've gotten a message in the chat, just to make sure that we all understand, indefeasibility of title means that absent the fraud exception, anybody who's not in the chain of title in the registry is out of luck. So if your title, if your interest is registered and a certificate of title issues, then all this stuff that we've been talking about adverse possession, or you know, figuring out what interest is applied and the bona fide purchaser for notice and law versus equity, none of that matters. Because once that certificate of title issues, you own the property. Okay. Justin asks, can we repeat what the referee does? Sure. The referee's job is to take applications for certificates of title that have been given to them from the registrar, right? Things that have been filed, applications for title. Review the applications and determine whether a certificate of title should issue. Basically, have you demonstrated that you are entitled, pun unintended, to registration? Okay, so does that answer your question, Justin? Great. To the person who messaged me privately, do you feel better now? Okay, great. So what happens, what do you do if you get this letter from the registrar of titles that says, hey, we're going to be issuing a certificate of title on this piece of land, and you're known to potentially have an interest in it. And you go, hey, wait a second, I have an interest in this land that would be wiped out. What do? This is when you file a caveat. Okay, so this is the caveat that we were talking about. Caveats are the way to protect any interest in land that is not registrable. So there are certain things, like, for example, mortgages, that you cannot register under the statute, at least in Jamaica. But you can file a caveat. So there are two types of caveats. There is a caveat against first registration. And so Jamaica doesn't have compulsory land registration, it's optional. And so land is being brought into the registry for the first time, sort of on a regular basis. And you can say, hey, wait a second, I hold an interest in this land, and I do not think that it should be registered in this person who has attempted to register it. Okay, so you file a caveat against first registration, and what you have done is you have asserted that you have a superior claim to title to the applicant, to the person who's trying to get the certificate of title. But there's a ticking time bomb in a caveat against first registration. You have, as the person who filed the caveator is the term. Put that in the chat for you. The caveator is the person who files the caveat. You have to take action to resolve your caveat by bringing it before the Superior Court, the Supreme Court in chambers within a month of filing. So you got to start the ball rolling on getting a judge to determine who has the superior claim within a month of filing your caveat. So these things move quickly.
Sir, question.
Yes, go ahead.
Is their registration system open to the public? Is it accessible to the public at large, or a select few?
That's a really great question.
Because I'm asking due to the fact that if you have persons registering lands and we don't know who has registered land, would it be restricted to attorneys at law or persons within the profession of dealing with land?
Yeah, that's a great question. I don't have a good answer for you, but your concern, I think, is that like people could be going in and secretly registering land and use that to dispossess the real owners.
Correct, because time is of the essence. You have a month to bring to file your caveat, so there's
Sure.
not sufficient time to eliminate the process of a fraudulent transaction.
Sure. The thing that you have to keep in mind is that the filing of an application merely starts the process of determining whether you're entitled to an application. And if it appears that you are, then the registrar sends out notice. And the notice goes to all known interest holders. So if we know that you're somebody who has an interest in the land, you'll receive notice. And that extends to those who are like in possession, right? So the notice goes to the physical property itself. So like if you have an adverse possessor who has been in possession for for the requisite time period, then they get notice sent to them. And notice is also published in the newspaper of record, whatever that newspaper is. So there's lots of ways for folks to find out if someone is attempting to register land out from under them. But yeah, to some extent, all of these systems rely on people acting in good faith, to not to assert interests they don't have, and B, to protect their own interests, right? Part of the incentive for this is to register your land, because then nobody can do that, can do this to you. So you don't have to necessarily buy into this logic, but this is the logic that underlies title registration systems. If you have some sort of interest in the land that is not registrable, like the classic example being a mortgage, okay? You can introduce yourself into the chain of title by filing what's called a caveat against dealings, okay? And a caveat against dealings is it's a caveat filed just like a caveat against first registration, but instead of asserting superior title, you're saying, hey, I have an interest that entitles me to consent to any transaction. So what that means is that you have some sort of interest in the land that gives you the ability or the power to review any transaction that anyone wants to do to make sure that they're not extinguishing your interest. Okay.
So that seems like just another form of a mortgage to me.
I mean, it is, right? But it's not a mortgage in the sense that there's no power of sale attached to it. So the mortgage carries with it the power of sale in the event of default, whereas the caveat against dealings, which is broader than just a mortgage, it applies to other types of interests as well, does not carry the power of sale. So does that, okay, great, awesome. So a caveat against dealings does not expire, right? There's not the ticking time bomb like there is with a caveat against first registration. Because you're not asserting any sort of title to the land, you're just saying, hey, I'm entitled to be kept in the loop and to know what's going on. And so as long as that caveat against dealings is present, no change in title can be registered without the consent of the caveator. Okay? So the last thing that I want to tell you about title registration is how it deals with priorities. So we talked very briefly about priorities, that basically if you had 2 legal interests or 2 equitable interests, the one that was earlier in time had priority. Okay? Title registration systems do away with that rule. And instead of earlier in time, the rule for priority is earlier in registration. So when there are competing interests, the first one to be registered and to receive the certificate of title wins. Okay. This has been a lot of information. So what questions do you guys have about title registration? Do you feel comfortable with this?
Sir, you just talked about caveats and dealing with priorities. I'm not really sure if I understand the concept of priorities, and then like, because that makes this part kind of confusing for me. But
Sure.
The whole point of taking priority in an equity an interest is so that one person gets the interest over the other. Is that the point of it?
So let me put a couple of things in the chat, and I see in the chat that Michaela is not the only one who's confused about priorities. So let me put a couple of things in the chat, okay? Okay, so the doctrine of priorities comes into play where we have more than one interest in the land asserted simultaneously. Okay, so for example, if we have 2 people who both are claiming to own the land in fee simple, and it doesn't matter whether it's a defeasible fee or a fee simple absolute, right? They both claim to hold it. They can't both hold it because they don't have a co-tenancy. So we have to have a situation where we can determine who owns it. Now, the doctrine of priorities only operates if the interests that we're attempting to prioritize are of the same type. So they have to both be legal or both be equitable. If one is legal and one is equitable, then the legal interest wins. I'm sorry. No, that's the American rule. Then the equitable interest wins. Okay. So let me say that again. There are one set of rules, and equity rules take priority. Okay, so if we have a legal interest and an equitable interest, so we have someone owns the legal title and then someone else owns the beneficial interest. Okay, the person with the beneficial interest has the priority. And the legal title takes subject to that beneficial interest. So do we make sense so far? Okay, let me see if I can think about this and explain it differently. So Go ahead, Adrian.
Sir, just a quick question. I don't know if it was able to clarify where you want to bring the point you want to bring out. But say, for instance, these transactions, we're just restricting the Jamaica only, or we just on a whole, the doctrine of priority covers even Barbados and other places?
The doctrine of priorities is a common law doctrine, so it is present throughout.
All right, fine. So when it comes to having, as you said, more than one person has an interest in the property, you're saying that if I register my document today, Tuesday, and then another person registered their document next week, that mine would take priority over any other documents that are coming after.
That is correct. That is correct. Under the common law, right? Under the common law, whichever one of you was earlier in time would take priority. So you have your documents that create your interest 2 weeks ago, but you're the other person, right? Abigail, who I'm picking on just because her name is first on the list of students, got her documents a year ago. Under the common law doctrine of priorities, her documents defeat yours. Okay, but the title registration systems, and this is true wherever you see title registration systems, the title registration systems say the first one to show up and register wins. Okay, now the issue with priorities is, as I say, they only apply to interests of the same type. For this purpose, for the purpose of registration, we don't care, because it's all about who's the first one to show up at the door. Okay? So what other questions do you have about title registration? Nicole, I see your hand is raised. Go ahead.
Thanks, sir. When you said to show up and register, do you mean to get there to start the process, or do you mean that the whole process of the registrar, whatever comes to an end, and then you have the registration? When is it start? When does registration, for the purpose of the priorities, start?
That is a great question. Let me double check very quickly. My reading of the material that's in the book and the stuff that I've seen is that the registration, so the issuance of the certificate of title, is the key event. That is the point where the title becomes indefeasible, which suggests that it may actually be possible to be second to file, but first to register, if the referee does not handle cases sort of according to the cab stand rule, right? And I don't know. I would assume, given that the referee would be likely to handle cases according to the cab stand rule, but I don't know that. So, okay. What other questions do you have about title registration? So Kira, a caveat against dealings specifically refers to land that is already registered. So what it says is, okay, we have this certificate of title that has been registered and has issued, but any future transactions have to involve me, the caveator. I have to know about them, agree to them, et cetera, et cetera. And it's intended, it's not necessarily a way to prevent registration. It's just a way to make sure that you know what's going on. And they may have the effect of preventing registration. So does that answer your question?
Yes, it does. So, okay, so then if the caveator doesn't consent, then the transaction wouldn't go through. Is it something like that?
That is correct.
Okay.
Sir.
Yeah, go ahead.
Does the person who has filed the caveat against dealings have to produce a reason why they're filing it, or they just file the document without stating or expressing any particular reasons why they're filing this caveat? Because, say for instance, as you refer to a person who has a mortgage against the said property, what is there any distinction between a person having a mortgage or a person who has a claim against the property otherwise than a mortgage?
No, because the purpose of the caveat against dealings is to incentivize the title owner to resolve the caveat, right? Because you can't transfer the land until you do, without the consent of the caveator. So, the registry does not distinguish between types of caveats against dealings. They're all just mechanisms to make sure that title doesn't transfer without taking care of those who have these other interests. So does that answer your question, Adrian?
A little, but I'm wondering, suppose somebody maliciously file a caveat.
I mean, entirely possible, right? At that point, right, the title owner does have mechanisms for resolving the caveat, either through negotiation or through litigation, right? So if the caveat is valid, then you want to do what needs to be done to resolve it lawfully, right? Pay off the mortgage, settle the claim, whatever. If it's malicious, then you can file in court and bring the caveator to a show cause hearing. So
okay.
where they will have to demonstrate why the caveat should continue.
Just that it seems like a system that potentially have a lot of defects. There's a reason for my queries.
I understand. The benefits of title registration basically amount to, and I see your question, Teresa. I'll get to it in just a second. The benefits of title registration have to do with the certainty of title and the efficiency of title. Okay, so the goal behind title registration is to make sure that title holders can pass title easily and quickly and cheaply, right? And I'm about to explain, it may be in the video, the alternative to title registration, which is done in some places in the Caribbean, and sort of we'll talk about how it works, what advantages and disadvantages it offers, and how it operates. Therese, your question, can I repeat what I said about when the registration process starts? So the registration process starts with the filing of an application. But the point at which title becomes indefeasible is at the end of the registration process when the certificate issues. And if the registrar does not process applications according to the cab stand rule, which is basically first in, first out, then it is possible, however unlikely, it is possible for a second filed application to be the first issued registration. So does that answer your question, Jerice? Okay, great. All right, so now to wrap things up, Adrian's raised, I think, some really salient points about title registration and some shortcomings that it has. But the alternative also has shortcomings. The alternative is deeds registration. And my research disclosed that at least as of 2013, which was when the information I found was dated, deeds registration was used in St. Vincent and the Grenadines, Grenada, Dominica, and St. Kitts and Nevis. That may have changed, but that's the information that I have. In a deeds registration system, the actual conveyance documents are recorded and maintained in the land record system. So you have like the land records room at the courthouse, and it's just this room full of books, and in the books are deeds and wills and documents that show the chain of title. And every time you sell a piece of property, somebody has to go down to the courthouse and find the deed that conveyed the property to your seller. And that deed will say, okay, this refers to another deed earlier in the chain of title, in some other book. You have to go and find it, and go and find it, and go and find it, all the way back to the original patent from the government. Okay. That's pretty expensive. Like, my experience with real estate closings in deeds registration systems is all in the US. The places that I worked that did real estate closings would charge between $1,500 and $2,000 US to do the title search. So this is an expensive step in the process that is just not present in title registration systems. With title registration systems, you hand it off to the state. The state tells you whether you're entitled to the certificate of title. There may be some fee involved, probably some sort of administrative fee, but it's not going to be nearly as high. And if they get it wrong, the state is the one who compensates you. You don't have to chase after anybody else. Right. It can be expensive and tedious. So, and if there's something missing from the chain of title, you may not be able to pass good title. So if the courthouse burned down at some point, and you know, that never happens, then you may have a situation where you can't transfer your land with good title because you can't prove that there's not someone else out there who owns it. So if you have a solid chain of title and there's an interest out there that is not recorded, so if on Monday, right, Albert sells to Bob, and then on Tuesday, Albert sells to Carol, okay? Carol does not take subject to Bob's interest. But the problem becomes with these deeds recording systems, how do we determine who wins in this situation? And there are 3 ways that jurisdictions do this, okay? And they're called race, notice, and race notice, okay? So if you have a race recording statute, then Bob and Carol just race to the courthouse. First one to the courthouse wins, okay? The first one to record gets it, and whoever's left out is stuck. Notice, okay? Notice means that Carol wins as long as she didn't have notice of Bob's purchase. And what we mean by notice is actual notice or constructive notice. So if Bob records, then now Carol has constructive notice. Or if Carol gets told by Albert, ha, I sold this land to Bob yesterday. He's such a sucker. And now I'm going to sell it to you, and now you own it. No, Carol doesn't win because she has actual notice. And then the race notice, right, requires that Carol both not know about Bob's interest and that she be first to the courthouse. Okay? So what questions do you guys have about deeds recording systems? I should tell you that this is not going to be, deeds recording is not going to be on the exam, because to be perfectly frank, it's not in either of the textbooks. But it is something that is used in the Caribbean, so I wanted to make sure that we talked about it so that you guys got exposed to it. So what questions do you have?
Sir.
So first Maisha's question, which is that title registration is fair game for the exam. Basically, if it is in a portion of the textbook that is assigned on the syllabus, it is fair game. So that's the answer to that. Okay, Adrian, go ahead.
Yes, sir. As you said previously, the registered system, you have a guarantee from the government and they accept liability for any issues that arise from the issuing of that certificate of title for the lands. In other form, which is the unregistered system, who would be responsible for any mistakes? Say, for instance, the clerk or the attorney goes to the registry, conducts a search, can't find a deed, or just as Maisha said, it can lead to a bit of fraud. He might represent that he didn't see the document for this particular time period in the chronology of the title. Who would be liable for his mistakes?
Great question. The answer is that it's going to depend on the jurisdiction. So these answers may vary slightly from place to place, but in general, the answer is that the seller is liable if they provide what is called a warranty deed. And a warranty deed is just a deed where the seller warrants, right, provides a warranty that they are selling to you, that they have the right to sell you what they are selling you. Okay.
Which jurisdiction is this, sir?
I'm sorry?
Which jurisdiction is this?
This is every jurisdiction that I'm aware of.
Okay.
So that uses deed recording. Another type of deed that may be provided is what's called a quitclaim deed. And a quitclaim deed just, it literally provides no warranty. The quitclaim says, look, I am not telling you I own this property, but whatever of it I own, I give to you. Okay. Quitclaims are common for like putting your spouse on the deed, right? So you own your home, you get married, you want to put your spouse on the deed so that you have a joint tenancy, you execute a quitclaim. That's usually what these are used for. If you're engaging in a transaction with like a random person and they offer to give you a quitclaim, you should run, because that's a scam.
Sorry, sir, are there any pros to this process?
To the deed recording system?
Yes.
Well, I think you might find some people who will tell you that deed recording is preferable because it minimizes the role of the state. So if you have like an ideological commitment to that, you may think that that's a good thing. That's the best I've got.
I'm just trying to see why, because you listed St. Vincent and the Grenadines, Grenada, Dominica, St. Kitts and Nevis. So I'm just trying to figure out why they maintain this system.
Probably to some extent inertia. And in Dominica and St. Kitts and Nevis, they have title registration systems, but they're not compulsory. So both systems are maintained in parallel.
So how does that affect the registration system when you're doing the process?
Well, title registration defeats deed recording. So if you take advantage of the registration system, then the chain of title maintained in the recording system no longer matters.
No, I mean, so like the process when you file an application for registration and they have to do due diligence, etc. Would it matter if there's a competing deed recording somewhere that's relevant to the title registration?
I mean, my guess would be that the referee would probably be very interested in knowing about that.
Okay.
So that would probably be something. I don't know if the referee would like reach out and seek out that information on their own, or if it would have to be brought to their attention. But certainly that would color my decision making if I were in the shoes of the referee. So, all right, we are out of time. So I will get the video recorded. I don't want to commit to get it done tonight because I do have the talk I'm giving this evening. But it'll definitely be up by tomorrow. And yeah, so we'll be in touch about what's going to happen next week. And so take care, and we'll see you then. We'll see you later.